I am Alan Levine, and together with my colleague in the Department of Government, Tom Merrill, we run the Political Theory Institute, which is the host of tonight's event. This is our Constitutional Day event, sponsored by the Jack Miller Center, and so we're very grateful to Jack Miller for their support. I just want to quickly mention our upcoming events this semester. On October 6th, we have a talk by Stephen Macedo of Princeton, In COVID's Wake, Science, Liberal Democracy, and Elite Failure. On October 16th, we have a talk by Bill Galston of the Brookings Institution, Liberalism Without Illusions. On November 6th, we have a talk by Daniel Mendelson of Bard College. It's our Lincoln Scholars lecture, Homer's Odyssey and its Migrations, Displacement, Wandering, Identity. And we wrap up on November 17th with Hannes Kerber of Boston College, The Politics of the Enlightenment, G.E. Lessing, and the Question of Tolerance. Now to today's event. Allegations of unconstitutional behavior by the Trump administration are many. Ignoring laws and changing budgets, firing heads of independent agencies, ignoring temporary restraining orders and preliminary injunctions, firing governmental employees without due process, ICE raids, masked men grabbing people off the streets without probable cause, mass deportations. That's only a partial list of the allegations, but the Trump administration claims all of its actions are constitutional. Are they? Are they constitutional if a feckless Congress allows it? Are they constitutional if the Supreme Court says so? What do we do if the Supreme Court is wrong? It has been wrong in the past. Is Trump making the executive great again or greatly abusing its power? That's our question for today. To help us think through this question, we're fortunate to have two really great experts. Adam White is a senior fellow at the American Enterprise Institute and directs George Mason University's Scalia Law School's C. Boyden Gray Center for the Study of Administrative State. That's a mouthful.
It's even more glamorous than it sounds.
In 2021, he served on the Presidential Commission on the Supreme Court of the United States. He recently chaired the ABA's Administrative Law section, and he's been a member of the Administrative Conference of the United States, where he remains a senior fellow. After clerking for Judge Sentel, he practiced administrative and constitutional law in Washington for many years. He's written for the Wall Street Journal, the New York Times, the Washington Post, National Affairs, Commentary, and the Harvard Journal of Law and Public Policy, among many others. He has his BA from the University of Iowa and JD from the Harvard Law School. Jeff Lubbers is a professor of practice in administrative law here at American University's Washington College of Law. Prior to joining AU, he taught at various law schools in the US and abroad, especially in Japan and China. And he served in various positions with the Administrative Conference of the US, including as research director. He's the author of the American Bar Association's Guide to Federal Agency Rulemaking and co-author of Administrative Law and Practice in a Nutshell. And he's written numerous law reviews as well. He earned his BA from Cornell and his JD from the University of Chicago Law School. The format for tonight is each speaker is going to go first Adam and then Jeff. They'll speak for 20, 25 minutes or so. Then we'll have some conversation, the three of us trying to specify points of agreement as well as sharpen the differences. And then we'll have 45 minutes or so of Q&A from you out there. And it is our custom to take questions from students first. So students start thinking. So please join me in welcoming Adam White. Adam.
So it's a real pleasure to be here. I just want to say, I just had the treat of spending about an hour with a bunch of AU students. Speak right into the microphone. Do this. Just had the pleasure of speaking with for an hour with a bunch of AU students. Please come down. There are seats in the front. Who will be bold enough to come down and take one of the open seats? It was a real joy to get to spend time with some of the students here. It's also a joy to be here both with Professor Levine and Jeff Lubbers, who's a friend and often a colleague. I'm an awkward person to pick for this spot for two reasons. One is Jeff and we disagree on some things, but it's not usually very pitched. Usually when we're disagreeing, I have to start wondering, what am I getting wrong? Second, as my friends know, I'm not the most natural spokesman for President Trump. Professor Levine mentioned I used to write for the Weekly Standard magazine, which no longer exists because it was a Never Trump magazine. I normally don't talk about my politics, but given the context of the event, look, I'm not a Trump guy. I was never Trump in 2016, and when people ask where I am on him now, do they say, "Are you still never Trump?" I say, "No, I'm never Trump. I'm probably more against Trump than I was 10 years ago." But in the context of today's conversation, I do want to say I'm going to make the case for a number of things that he's done so far in this administration with respect to presidential power. Not on immigration. I disagree with the way he's actually administered immigration, the actual day-to-day treatment of people. And on a number of other issues, I do not agree with him. I totally disagree with him. But on a number of very important issues with respect to executive power, and also a lot of the things that have happened within agencies in terms of major reductions in force, I think he's actually operating within his legal limits. And so that's my starting point on this. My main point that I want to get across is that I think the great problem right now is less President Trump and more the kind of office that we've created for him to occupy. I think Donald Trump is uniquely ill-suited to be a president in our system as a matter of temperament. He's only in a position to do a lot of what he's doing because of the office that we've created around him over the last century, okay? I'm going to talk a little bit about how we got to this point and how I understand what he's doing in that context, and then both how I would judge some of the legal merits and how I think the Supreme Court is going to react. Let me say a few words about how we got here. Every 4 years, we hold the everything election. It's an everything election. Every issue under the sun seems at stake in a choice between two people, between Donald Trump and Kamala Harris, between Donald Trump and Joe Biden, between Donald Trump and Hillary Clinton, between whoever ran for president before Donald Trump. It's now so long, I've kind of forgotten. But every 4 years, it seems that everything is at stake. Whatever issue it is that you care about, most likely it feels like it's at stake in a presidential election. And not just policy issues like climate or immigration or trade. The very future of the Supreme Court always seems at stake in a presidential election. What happens after the everything election? Somebody wins, somebody loses. There's all kinds of speculation about who's going to get the really good jobs in the administration. And a few months later, the president comes to office, swears his oath of office, and what does he immediately begin to do? He starts to sign a tidal wave of executive orders. Executive orders on, now it's on day one, 30 executive orders on every issue that his party cares about, on every issue under the sun. From the moment the president takes office, he begins writing the rules that will govern us for the next 4 years. Then what happens after that? He's announcing these rules, his agencies spring into action, and immediately the lawsuits happen. The president's had a head start maybe at that point, three months, maybe more, to plan the rules he wants to announce. But the lawsuits happen immediately. Hamilton said that there'd be energy in the executive. Frankly, in our day and age, the most energetic part of government is the federal trial judges and the quickness with which the cases can move up and down the docket, even to the Supreme Court in just a number of days. And so you'll have litigation And very quickly, things begin to bog down. What's Congress doing in all of this? Congress is doing what Congress always does best. It's sitting and more or less doing nothing, it seems. Or at least it's waiting for things to happen. And then the members of Congress will tell you what they think of all of this. They like it, they hate it. They'll hold hearings. They'll tell you how much they like it, how much they hate it. We all know this. At this point, you're probably wondering, they invited this guy from AEI to tell me the obvious. Why are we even here? Even though this is so obvious, I don't think we really understand what I just described. We all know that the president acts like our lawmaker in chief, like a king. President Trump, maybe more than anybody before him, but it has been a steady trend line for a long time of each president asserting more executive power than the one before. And I think in the last 15 years, it's only accelerated. Our president thinks of himself as our legislator in chief. What are the courts doing? They're hearing and deciding cases, but these cases that they hear, especially at the beginning of an administration, where they move so quickly, they're making discretionary judgments, partly about the law, but also a lot of prudential factors about who's benefiting, who's burdening, when should we intervene. Sometimes they write an opinion, sometimes they just have time to get out an undescribed TRO or an injunction from the Supreme Court. Professor Tom Merrill in the front row, he knows exactly what I just described. Somebody who moves quickly, energetically, sometimes without explanation. In this day and age, after the president signs the laws, the new laws that he announces, our district judges, even the Supreme Court sometimes, is acting in the style of an energetic executive. And you probably know where I'm going with this. What's Congress doing all this time? When it's just waiting for things to happen, it holds hearings, it tells you its opinion of things at the end. Just as we've trained presidents to act like a king, and we've trained judges to have to think on the fly like an executive, we've trained Congress to think like a court. They wait for things to happen, they announce their judgments. It's not a real court of law, it's a court of public opinion. But think about it. Think if you were to ask, who's one of the AI image companies, you can create a picture of anything, Midjourney. You ask Midjourney, show me a picture of a 19th century Congress. They'll show somebody like John Calhoun or Daniel Webster in the well of the Senate talking to his colleagues. Ask Midjourney to paint a picture of Congress today. It's a hearing with a bunch of people arrayed across a bench. They're not wearing robes, but they're holding hearings like a court of public opinion. They've shaped themselves to think and act like judges, not like legislators. That's the great problem in our day and age. We've taught presidents to think like kings. Judges now have to react and act almost like executives. And members of Congress more or less act like judges. Each branch is doing slightly the wrong job. The one they weren't built for, one they weren't really built to have the virtues for either. There's a big difference between an energetic president and a thoughtful and moderate member of Congress. And what it adds up to, and especially for the students who just spent the last hour and a half with me, where we talked about Hamilton's notion of steady administration, this is Hamilton's nightmare, because every 4 or 8 years, we have a regime change in politics, where all the written laws change at once, and the rest of society has to grapple with these enormous swings in policy. My bottom line is, it's not just that presidents aren't, including President Trump, they aren't making execution great, but it's not about Trump. It's that we long ago created a system where you can't have great execution anymore, because presidents have to spend more of their time writing laws and thinking about the future, what laws, what executive orders should govern, than actually administering quickly, steadily, faithfully the laws that the Congress passed. That's the situation we're in, the backdrop of what's happening right now. So then I look at what's happening right now, and I will say some words in defense of what President Trump is doing. When we think about what President Trump is doing right now, I would urge you to think in 2 categories: who and what. These are the 2 big choices that presidents make right now: who to appoint or to keep in office at the top of agencies, and what policies to create. President still gets to appoint officers, and in his agencies like the EPA or Treasury, he gets to pick who's in charge of those agencies. And it's more or less been settled since the very first Congress, more or less, that for what we think of as executive agencies, Treasury, State, Interior, an agency run by one person, for those, the president can fire people at will. It's been a much more complicated question for a century over whether the heads of the independent agencies, these multi-member commissions, there's usually 5 people, usually. We'll talk about the Fed in a second. But for most of these agencies, 5 people, some Republicans, some Democrats, statutes say that they have some independence. President Trump has started taking truly unprecedented action to fire the heads of independent agencies. He fired Alvaro Bedoya and Slaughter, not Ann Slaughter. Was it Ann Slaughter, the head of the FTC? He fired 2 Democratic members of the FTC. He fired a Democratic member of the National Labor Relations Board. He fired a member of the Merit Service Protections Board and one other, maybe the Consumer Product Safety Commission. Over and over again, President Trump is firing officers who the law says have a measure of independence from him. I think he's on the right side of the law, constitutionally speaking. A century ago, these agencies, they operated much more slowly. They operated sometimes almost like a court. The Supreme Court used to refer to them as quasi-judicial, quasi-executive. I think it's kind of an open question whether you could have that kind of agency constitutionally independent from the president, or whether you could have that agency independent from the president, have it be constitutional a century ago. Today, I think it's almost impossible to say that. We've given so much enforcement power, so much rulemaking power to agencies that they wield not in a kind of sleepy, expert way, a dispassionate, deliberative way, but they operate like any other executive agency. The Federal Trade Commission may well have been sort of properly made independent a century ago. Not anymore. The FTC is every bit as fast and political and partisan and executive as modern agencies are today. I put the Fed in a different category. Maybe we'll save that for the conversation later. I see the Fed differently, and I've been writing about that recently. But when it comes to the president's power to fire the heads of independent agencies, I think President Trump is on very strong ground. And by the way, I think the Supreme Court's going to affirm him. They've been moving in that direction for at least the last 15 years, if not more. Next year is the 25th anniversary of an article by then Professor, now Justice Elena Kagan, called Presidential Administration, where she was tracing the evolution of presidential control of agencies. She didn't make the case for the president to fire the head of the FTC. I guess she'll dissent from the majority when that case gets to the Supreme Court. But I think President Trump is on very strong grounds when it comes to his ability to fire people, or to fire the heads of agencies. Now, when you get to DOGE and what it's been doing, radical cuts in bureaucracy and in spending. On the one hand, what he's been doing has been radically destabilizing, right? You just think of the sheer number of people who have lost their jobs, government programs that have been disrupted, perhaps permanently, by this radical disjuncture in the presidential administration. I told the class before, last term, President Biden nominated me to be on the board of the Corporation for Public Broadcasting. I was told, not by the Biden White House, but by somebody in that process, I was the only Republican they knew who really liked PBS, which is true. When they asked me if I would join, I said, well, could I meet the guys from this old house? That'd be pretty cool. That agency, the PBS and NPR have been perhaps permanently marred by the president's policies. But by and large, I think the president and his administration have operated within their legal limits, within the discretion given to them by statute, within the limits of a lot of the grant contracts and so on. Every single one of these is different. Every statute is different. Every contract is different. But by and large, what we're seeing right now is President Trump operating within the legal system that's been created. We have the everything election because Congress, for a century and a half, has delegated enormous power to presidents. Presidents operate in an almost entirely discretionary environment. Again, I think we've taught them to be kings. It's not that they seized power. I mean, they often do on specific issues. But by and large, the great sweep of American history has been Congress shoveling power into the president's hands and not presidents seizing it. One of my favorite legal thinkers, John Hart Ely, he was a great thinker of the 20th century. He wrote a book called Democracy and Distrust, Defense of the Warren Court. He also wrote a book called War and Responsibility, about how Congress had given up all of its responsibility over wars and peace. And he said that it would distort things to suggest that presidents seized power over war. Rather, Congress gave it away because responsibility is very scary stuff. And I think that's the story of our government in general, going back to the post-Civil War era, over and over again, shoveling power in the president's hands. And now we're seeing President Trump, who again, I think temperamentally is uniquely ill-suited for the presidency, making the most of a situation that Congress created for him. Now, I will say on the what cases, the policies that end up coming out of the administration, regulations and so on, I think the Trump administration is going to have a much harder time with that. Because just as for the last 15 years, the Supreme Court has been opening the president's discretion to fire the heads of agencies, they've been tightening the president's policymaking discretion. A few years ago, the Supreme Court got rid of Chevron deference. They said courts shouldn't defer to agencies' new interpretations of the laws. That really squeezed president's policy discretion. We saw it in a related series of cases called the Major Questions Doctrine, where the Supreme Court said whether it's COVID vaccine mandates, climate policy, and a couple other very important issues. And whatever one thinks of COVID vaccine mandates, I'm in favor of the vaccines. Well, whatever one thinks of climate change, I think climate change is man-made and we need to do something about it. Whether you agree with me or disagree with me, we can all agree these are some of the most important issues of our time. And the Supreme Court said, for that kind of issue, we're not going to defer to presidents anymore. We're going to assume that Congress is responsible for those issues. Also in President Trump's first term, the court threw out Trump's efforts to add the citizenship question to the census, threw out his efforts to roll back President Obama's DACA immigration policy. Didn't say he couldn't necessarily do it. They said you're doing it the wrong way. It needs more explanation. Over and over again, my point is the courts are less and less deferential to presidents. And I think we're going to see that in the next couple of years. We're not seeing it right now on the shadow docket, these early cases, and I'll distinguish that why I think that's the case for now. I think in the long run, President Trump is going to lose the case on tariffs. I think he is going to lose some of the spending cut cases. I do think they've crossed some legal lines in some cases. And I think when they start finalizing major regulations on climate policy, on immigration, on a few other things, I think they're going to have a harder time in court than they're having so far. But they are certainly, I think, going to win over and over again on firing the president's power to fire agency heads. And also, I think, on a lot of the spending cuts. I'll just end on a philosophical point. Maybe where I started talking this afternoon about Alexander Hamilton. One of the things I told the students, they read Federalist 76. I'm up on time, right?
You're good. You're good.
In Federalist 76, Hamilton says, the true test of a good government is its tendency and aptitude to produce a good administration. And I point out to the students, he's quoting himself from earlier in Federalist 68, showing that it's not just judges and legal academics who can quote themselves. Hamilton did too. It's fascinating, right? That of all the things that Hamilton wrote about the Constitution, the judiciary, everything, he says the test of the government is whether it tends to produce good administration. And as we explored in the class, I think he means not just energetic administration, but steady administration. And those are two slightly different things. You can have very energetic execution, President Trump, doesn't necessarily make it steady administration, not President Trump. And it's not, therefore, good administration. That was Hamilton's true test. And I think we're failing that test now, not just in Trump's time, but in President Biden's time, Obama, all the way back to Bush, this explosion of federal power, where presidents have enormous policy swings from one administration to the next. It's Hamilton's nightmare. And if you take some time, you take Professor Levine's class, and you read the Federalist, Professor Merrill's class, read the Federalist, read it closely, and you'll see how far we are from his vision of good administration. It's not just Trump's fault. He's uniquely ill-suited for the presidency, but we've made the modern presidency uniquely ill-suited for constitutional government. So now Professor Lubbers and I will find some things to argue about, but thank you for humoring me so far. We take Tom and
Well, thank you very much for inviting me, Alan. It's a real pleasure to be here on the main campus to celebrate Constitution Day. and to share the stage with Adam as well. I've always respected Adam as a commentator. He does a great job of directing the Boyd and Grace Center. He always makes sure that all views are represented in his programs. And he's one of the nicest down-to-earth people in Washington, even if I don't always agree with him. And I didn't find that much to disagree with him in today's talk. But before I take on the topic that Alan has assigned us, I wanted to mention a few general things that are sort of appropriate for Constitution Day. First, last week, I went to a Constitution Day event at the Library of Congress, and there was a film about Oliver Wendell Holmes, which is pretty interesting, but I was reminded about the library's great online resource called The Constitution Annotated, which used to be a thick book, and now it's all online. And for example, a couple of its riches are two interesting tables, one of all the laws held unconstitutional by the Supreme Court, and another of all court decisions that were overruled by subsequent Supreme Court decisions. Pretty interesting to look at those tables. And I learned that after Marbury versus Madison was the first one, of course, where the federal law was held unconstitutional, but the court didn't overrule another federal law until the Dred Scott decision about 50 years later. They overruled some state court decisions, but so that was one thing I wanted to mention. And another thing is I have this book that I found in a used bookstore, a little pamphlet about the Constitution by a historian named Philip Dorff. And this edition was 1958. I think it's been updated, but there's a little passage that I thought was pretty interesting about the Constitutional Convention, where he says, the delegates to the convention were all chosen by existing state legislatures rather than by direct vote of the people in each state. In general, they represented the solid conservative men, and here I have to say, perhaps unnecessarily, they were all men, conservative men of the nation, the planters, merchants, ship owners, and professional groups. All but 12 held seats in the Continental Congress. 7 had been governors of their states. But any impression that the convention was composed of venerable patriarchs is contradicted by the vital statistics. The average age of the founding fathers was 43. Madison was only 36. Gouverneur Morris, 35. Edmund Randolph, 34. Hamilton, barely 30. Pretty interesting. Yet they produced a constitution, although flawed in many important respects, has stood this test of time for almost 250 years. It also made me think about what a constitutional convention held today would be like. Would that be a good thing to do? Or would that be like opening Pandora's box? Take a look at Article 5 of the Constitution, the Amendment Clause. It could happen. Maybe that's a topic for next year's Constitution Year. Now I'm going to take up the assigned topic. And it's hard to know where to start. But let me begin by quoting the president himself. In 2019, President Trump said in a speech, quote, I have an Article 2 where I have the right to do whatever I want as president, but I don't even talk about that. In his second term on Meet the Press, he was asked, don't you need to uphold the Constitution as president? And he said, I don't know. Has any president ever said anything like that before? Now, this I have an Article 2 statement is a layman's version of what has become known as the unitary executive theory, positing in its most muscular version, supported by some conservatives, that the president has the power under Article 2 of the Constitution to control the entire executive branch and all the agencies, officers, and employees in it. There's a large body of literature on the unitary executive theory, both supporting it and challenging it, much of which I haven't had time to read. But in a speech that Cass Sunstein made to our law school back in 1992, before I got there, he made some strong historical and textual arguments against this version of the unitary executive model of the presidency. He pointed out, quote, if anything ought to be under the president's control, it is prosecution via the Attorney General. Yet the framers actually did not put prosecution under the hierarchical control of the president. They created an Attorney General, but they also created district attorneys who who are not subject to the control of the Attorney General or the President. In fact, the Department of Justice wasn't created until 1870. Second, he points out that although there was clear support among the framers for giving the President removal powers over the heads of a new Department of Foreign Affairs, now State, and the Department of War, now, well, war again. James Madison successfully argued for making the controller of the currency a key official in the new Treasury Department independent of the President. He also made the same argument for the first Postmaster General. And as a textual matter, Professor Sunstein asked, how about Article 2 itself? It's much briefer than Article 1, which has a long list of powers for the Congress. One of the few enumerated powers given to the President in Article 2 is the Opinions Clause in Article 2, Section 2, which gives the President the power to demand the opinions in writing of the heads of departments on any subject relating to their duties. Doesn't seem like a big power. But Sunstein asks, why would the framers take such pains to specifically give the President such a power if he could direct their actions and hire and fire them at will? Furthermore, in Article 1, the framers added the necessary and proper clause, which gives Congress constitutional authority to enact all powers or all laws necessary and proper to carry out into effect not only the powers of Congress, but all other powers vested in the federal government or in any department or officer thereof. So at a minimum, I think that suggests that Congress should have considerable control over the organization of the judicial and executive branches. Now, of course, Article 2 does provide that the President shall take care that the laws be faithfully executed. But notice that that power is not up front in Section 1 or 2 of Article 2. Instead, it's sandwiched in Section 3 between some minor powers given to the President, like that he report to the Congress on the State of the Union, and that he shall receive foreign ambassadors. It's right after that. And it's right before a clause that states his duty to give all officers their commissions. So this take care of power, if you look at where it is, can just as easily be read as a requirement that he faithfully follow Congress's will as a mandate that he can have royal control over everything that happens in the executive branch. Now, of course, as Adam said, if congressional leaders are unwilling to push back when a president usurps their constitutional prerogatives, that leaves only the judicial branch as a bulwark, which is perhaps why there have been 404 lawsuits filed against this administration as of yesterday. And that's according to the litigation tracker maintained by Just Security, which you can find on the WCL Pence Library website. The plaintiffs have won a large majority of these lawsuits. It's a little hard to count, but I think it's generally thought that they won about 2/3 of these lawsuits in the federal district court, many of which verdicts were not appealed. Their record at the Court of Appeals is a bit more mixed. I think there's a slight majority of wins in the courts of appeals. Of course, the Supreme Court has intervened in about 20 cases, and they've temporarily stayed about 3/4 of the lower court injunctions that they've accepted for review on its so-called emergency or shadow docket. Now, promoters of the super strong unitary executive model point to the 1926 case of Myers versus United States as the leading precedent. Its narrow holding was that Congress could not give itself a role in the removal of postmasters. But there was a lot of language in the opinion of the president had unrestrained power to fire the officers he appointed. Now, of course, it's not surprising that ex-President Taft, who wrote the opinion, had an expansive view of presidential powers. But there were some dissents, including dissents by Justice Brandeis and Holmes. Brandeis wrote a long dissent, which wasn't that common at the time. And he made some good arguments. First, he pointed to Justice Story's famous 1983 commentaries on the Constitution, which stated that in 1789, the Senate's power to require its consent for removal of inferior officers was assumed. Second, he cited Federalist paper, hesitant to say this because Adam knows the Federalist papers a lot better than I do, but he cited Federalist paper 77, where Hamilton construed the appointments clause as also assuming Senate consent to removals. Third, Brandeis contended that the appointments clause clearly grants to Congress the legislative power to create offices, to prescribe the tenure of such officers, and to prescribe how the appointment of inferior officers can be made. So we argue that this power to prescribe tenure has to involve prescribing the power to prescribe the conditions under which incumbency shall cease. Especially, he said, because the Constitution didn't deny Congress the power to control removals, it was silent. And fourth, he said that this practice had been accepted for a long time, that numerous bills had been signed by every president since 1861 that had provisions like this for cause removal protection, including Senate President Taft himself. Now, as we know, and then 9 years later in Humphrey's Executor, the court did accept the for cause removal protection of the FTC commissioners. And some of the reasons they gave back then were admittedly a little ill-suited to today's independent agencies. But the main point was that the court deferred unanimously to Congress's intent to create boards and commissions with special expertise that were supposed to act at some arm's length from the president. And the Congress then went on to create at least 25 of these agencies. And in 1958, the court reaffirmed unanimously Humphrey's Executor, overturning President Eisenhower's attempt to fire a member of the purely adjudicative War Claims Tribunal, even though its statute didn't even say anything about the removal protection of the War Claims Commissioners. This case was called Wiener versus United States. I tell my students it's very easy to remember this case because the opinion in the Wiener case was by Justice Frankfurt. It's not that easy to make administrative law judgments. Anyway, so why do I go through this recitation? Partly to respond to Adam, but President Trump has been on a firing spree. You mentioned some of the agencies, but I have a longer list. The NLRB, CPSC, MSPB, EEOC, FEC, FTC, Federal Reserve Board, Surface Transportation Board, and a bunch of small boards and government corporations, not to mention the heads of the FBI, CDC, Bureau of Labor Statistics, 23 inspectors general, and numerous federal civil servants. He's even reached into the legislative branch to fire the Librarian of Congress and the head of the Copyright Office, claiming that they are performing executive functions, which maybe they are. Now, I'm sure Adam will has reminded everybody that he has some colorable legal arguments and that he probably has the Supreme Court on his side in most of these cases, maybe not all. And I guess it wouldn't be the greatest tragedy if some of these independent agencies lost their independence. But do we really want the president to have full control of the Federal Reserve Board? That's one exception you've mentioned. What about the Federal Election Commission? Or the FCC? We're seeing what could happen there. What about the NLRB or SEC? And fundamentally, since Congress creates these agencies, why can't they have a lot of say in how they're structured? As Justice Brandeis asked in 1926. Now, I do have some confidence, as does Adam, that the Supreme Court will find some of the president's actions to be illegal, such as his attempt to end birthright citizenship, to try to skirt the Impoundment and Control Act by freezing already appropriated funds, to invoke the Alien Enemies Act of 1798 to deport migrants, or to levy crippling sanctions on law firms for whom for hiring people or representing clients that President Trump doesn't like. And I think agencies will lose if they take improper shortcuts to rescind existing regulations. But many of the president's actions are likely to be found legal. They just violate accepted norms that presidents have followed for many years. Some of the White House actions are based on very broad readings of statutes, such as where the Congress has provided presidents over the years the power to declare emergencies, to create categories of federal employees which are accepted from the civil service hiring and firing rules, or to federalize the National Guard in some circumstances. These statutes have a lot of discretion, a lot of wiggle room, because they're supposed to handle real exigent circumstances. But no president has pushed the envelope as much as this one, with congressional acquiescence. Now, some of his actions are clearly within his discretion. And I think you can think of a lot of them. For one, for example, pardoning all of the individuals charged or convicted in the January 6th attack on the Capitol. That's clearly legal and within his discretion. That doesn't make it right. Can he direct the Attorney General to mount investigations of his political enemies? Constitution doesn't prevent that. But from the time of Nixon's enemies list, presidents have had a hands-off attitude toward DOJ investigations and prosecutions until now. Can he bring on Elon Musk and the Doge team as special government employees, gather all manner of data held in agencies' files, and target whole agencies' divisions for elimination? The law does allow for hiring of special government employees, and it doesn't restrict their access to databases, so maybe so. But they were never supposed to supplant agency leadership. Can he call for the impeachment of judges who have the temerity to rule against? Sure. He has a bully pulpit, a term that may have a new connotation today. But that has corrosive effects on our rule of law. Can he strip Biden administration officials of their security clearances and Secret Service details? Probably, although no prior presidents have done that sort of thing to their predecessors. Can he cut off federal contracts or access to federal buildings to law firms that are in his bad graces? No, I don't think he can. I think that's a violation of the First Amendment. But he can threaten to do so in the hope that they'll capitulate by undertaking millions of dollars worth of pro bono work for his causes. A number of law firms have capitulated. Can he kick out of the military over 1,000 patriotic service members simply because they are transgender? Maybe. The Supreme Court allowed this ban to proceed while legal challenges work their way through the lower courts. Can he sue TV networks for editorial policies he alleges were defamatory? To watch them squirm and then pay up because they need approvals from the FCC that he now controls? Yes, he can, and he has successfully done so. Can he accept a $400 million jet for his presidential library, or hold international conferences on his own properties, or get approval from Vietnam for his family business to build a $1.5 billion golf resort there in the middle of tariff negotiations? Yes, if Congress doesn't call him on it, even though this seems to be a violation of the the Foreign Emoluments Clause, which I should probably read here. No officer holder shall, without the consent of Congress, accept of any present emolument, office, or title of any kind from whatever from any king, prince, or foreign state. Can he order bombing of Venezuelan boats in international waters without a declaration of war, simply by asserting Article 2 powers? To be determined. Some members of Congress have squawked about this, but is there any real pushback? Can he order the removal of exhibits about slavery from all of our national parks, including, of all places, from Harper's Ferry? Apparently he can, and I haven't heard a peep from any members of the Republican Party, the party of Lincoln, about this. I could go on, but I'll stop there. The president can take a lot of these actions, secure in the knowledge that Congress won't push back, and that the Supreme Court has so far been pretty tolerant. So as we celebrate Constitution Day, stop and think about what really does make our country great. Some of these things are core constitutional principles that we should be and are celebrating today. Checks and balances, separation of powers, freedom of speech, separation of church and state, an independent judiciary. Some of our most valued institutions, our university system, which is the envy of the world, the Smithsonian, our civil service, the Department of Justice that was a beacon for civil rights, our national parks and monuments, NIH, the FDA and CDC, the USAID and Voice of America, NASA, the Census Bureau, the Bureau of Labor Statistics, our system of inspectors general, an independent Federal Reserve Board. And I'm tempted to add our late night shows. I submit that these are all either under attack or being intentionally eroded by a president who is pushing the envelope on existing legal restraints and breaking norms that have been assumed to apply to previous presidents, all in the name of Article 2. So our great Constitution was designed to prevent any one branch from becoming too powerful. That's what checks and balances are all about. But the current leadership in Congress has failed to be a check in all these matters so far. It's up to the courts and, of course, to we the people in the next election. So I'll close with a passage from de Tocqueville's Democracy in America, in which he quotes a letter from Thomas Jefferson to James Madison, written in 1789. Jefferson says, "The executive power in our government is not the only, perhaps not even the principal object of my solicitude. The tyranny of the legislature is really the danger most to be feared and will continue to be so for many years to come. The tyranny of the executive power will come in its turn, but at a more distant period." I hope I'm wrong, but I fear that time is coming.
Okay. So, Adam,
Just get my water. I'm not seeking a rebuttal. I just. Get my water. No, this one's yours right here.
So Adam, is there anything you would like to say in response to Jen?
Well, as always, I think Jeff got a lot of things right. I mean, I started keeping track of things I agree with him on, and I lost.
I would say, and this is the main point where I think he gets a good point against me, really.
Is on the history of Article 2. It is true, right, that the U.S. attorneys had a measure of independence from the president in the first instance. It also is true that the controller of the currency in the first Congress had a measure of independence. I see the controller of the currency as a little different, like the Fed. I think it's primarily a monetary power, not an executive power. And so I see why the controller would get some independence. They also debated the Treasury Secretary, made him fully susceptible to the president's powers. But I'd say by and large, I think the purpose and structure and implementation of Article 2 over time shows that when it comes to actual executive power, it's not only constitutional for the president to have control, it is, structurally speaking, good for the president to have control for the sake of transparency and accountability. Justice Scalia, in his wonderful dissenting opinion in Morrison versus Olson, said, yes, it's unthinkable in many ways the president could have power over a Justice Department that interprets him or that investigates him. But the only thing more unthinkable than that is allowing prosecutors to not ultimately be accountable to presidential oversight and just giving them full independence to roam the country, investigating people and bringing them in front of grand juries. Can I just maybe say 2 more points? Okay, so when Professor Lubbers was discussing Myers versus United States, the first case where the Supreme Court made some pretty sweeping statements about the president's Article 2 powers. He was firing a postmaster general in Portland, Oregon, right? I don't know what the heck was happening in Oregon that the president was suddenly up in arms about this. It is true that Chief Justice Taft's opinion has some major caveats in it. But I don't think it's necessarily caveated in quite the same way that Professor Lubbers says. I might be misreading the case, but I took it to be a much more sweeping endorsement of presidential power than he reads it. Likewise, the case that followed 9 years later, Humphrey's Executor, where the court said the president does not have constitutional authority to fire the heads of quasi-judicial, quasi-legislative independent agencies. I actually think the background of that case where the court was saying, as opposed to executive agencies, that might have, or agency, try that again, as opposed to executive agencies, which are susceptible to the president, this kind of independent non-executive agency can be independent. I think the background assumption cuts in my favor on this, that the court even there was conceding that agencies with genuine executive power, primarily executive power, can and should be constitutionally susceptible to the president's oversight. And frankly, I think the court's recent decisions about independent agencies reflect that reading of Humphrey's executor. They're not so much overturning Humphrey's executor as they are working within the limits of Humphrey's executor. I want to make one big picture statement, but and also I do want to say one place where I agree is on birthright citizenship. I think President Trump's policy is wrong on the law, wrong as a matter of history, and I think just recklessly destabilizing and how casually he just announced certain people are not or were not citizens. So I just want to make sure I said that. But before I get into a big picture, Professor Lubbers, you're warming up your microphone. Thank you, Mr. Area, so I didn't know if you wanted to respond. Let me just say one last thing. Professor Lubbers points out that the provision of the Constitution, the president will faithfully execute the laws. Yeah, it is sort of buried in there. And I think that reflects the early American government's sort of lack of a lot of big policy laws to execute. The president's big job in the early republic really was appointing people to administer tax laws, appointing diplomats and so on. But now in an era of so much federal law on policy laws, I'll call them, the obligation to faithfully execute the laws is incredibly important now. The word faithfully is an interesting word. It only appears a couple of times in the Constitution. Faithfully execute the laws. The president swears an oath to faithfully execute his office. There's another provision where the states have to give full faith and credit to other states' judgments. These are all areas of government where the actor's instincts might be to not do what needs to be done. A president might not want to execute laws that his predecessor made. A state might not want to enforce the judgments in another state. It's very hard to actually force them to do that. It's like pushing on a string, trying to get a president to enforce a law that he doesn't want to enforce. The word faithfully is so important there. I once thought I should write a book called Faith-Based Constitution. Really calling, I'm glad somebody laughed. Thank you. We met earlier. In the end, it just comes down to what's in the president's character, what he feels is politically necessary, but also what he thinks is morally necessary. It's why he swears an oath. And I can come at this like a broken record in so many different ways, but the corrosive effect of 150 years of giving presidents big discretion on this issue, and then that issue, and then that issue, that's the process by which we taught them to be a king. It's very hard for a president to faithfully execute the laws when what we've mainly done in our country's history of delegating power to the president is just over and over again tempting Lord Acton's wisdom that absolute power corrupts absolutely. It does. And in so many small and even big matters, we've given presidents absolute power. Congress gave them that power. And so I don't think we can be surprised. Presidents don't feel contained by anything else, least of all their consciences anymore.
Is this on? Yes. So I basically responded to Adam a lot up there, but just a few points I wanted to make. You said a couple times, we've given the president so much power. Well, Congress has been giving the president this kind of power, and in fact, the very first Congress delegated to George Washington the power to write regulations on how pensions given to Civil War veterans should be paid. So the delegation that took place in the very first Congress, and it's gotten a lot more since, of course. So I think if it's a problem that the Congress is delegating too much discretionary power to the president, why isn't it part of the solution for Congress to be able to delegate power to these somewhat independent agencies? They're not completely independent. I mean, the president has to appoint the members with Senate consent. The president gets to pick majority from his or her own party. The president usually gets to appoint the chair of the agency. So the president ends up having a fair amount of policy input into these commissions. So if the problem is too much discretion being given to the president, why isn't it part of the solution? In some situations, Congress should be able to give power to these quasi-independent agencies.
Man, it's a great question. It is a great question. And I think none of you have taken administrative law yet, but someday some of you will, hopefully Professor Lubbers. And what you'll see is you spend half the class learning how we've coped with presidential discretion by trying to make agencies more like a legislature, rulemaking processes and so on, some kind of deliberative process before they announce these rules. And the other half of administrative law is where we show how we've tried to shape these agencies to act more like a court, how they adjudicate particular issues. We've tried to create checks and balances within this system of administrative law to basically replicate or supplement all of the constitutional structural limits that went away piece by piece as Congress just delegated policymaking power to the energetic executive. And as a practical matter, I can appreciate that. I understand why we need these, as I guess Madison would call auxiliary precautions inside of administrative law. But I think there we were trying to cope with symptoms that can really only be cured by getting to the root of this, which is the delegation issue. I worry about the Supreme Court being too aggressive with the non-delegation doctrine. There's a real risk of judicial activism there. But I do like what the Supreme Court has done in other cases, like the Chevron deference cases and others, where they basically told agencies, you don't have as much discretion as you want. And people, if you don't like this, take your problems to Congress instead of agencies. But to the deeper point about haven't we been doing this from the start? And that is exactly right. When I teach administrative law on day one, I give students a list of the first year's worth of statutes that Congress passed, and it's the post roads, it's the tax statutes and so on, where the executive did get a lot of discretion. And we play around with it. I say, how much discretion should the president have in making a road? Does Congress have to specify the exact route and everything? No, of course, presidents are always going to have discretion. The best essay on this, my favorite in the Federalist, is Federalist 37, about how you can't get away from this discretion. But the problem is, maybe those first statutes were just little things, but every time Congress delegated a little power to a president, it changed both the way the president thought, and also it changed the way Congress thought, because every little bit of delegation creates more need for oversight, more political bang for the buck in oversight. It's like a scale, and just little by little, the balance shifted from legislation to oversight. Congress changed all of its own incentives along the way. I like what the court's doing because I think it might be the first step out of the cul-de-sac. And I don't want the court to do too much. I don't want the courts to run the country. They shouldn't, and I don't think they are yet. But I do think the lesson from history, beginning with those small, well-intentioned delegations, and they've been well-intentioned the whole way through, Interstate Commerce Act, Steamboat Act, the Federal Trade Commission Act, always there was a reason to delegate power to this agency of the president. But we're now living in the consequences of that.
I just want to make one more comment, that we should get some questions. So I guess two things you said that comment. One is on delegation itself, because why would Congress want to delegate powers to the executive branch agencies to make law, so to speak? And I tell students who are interested in maybe taking administrative law that this is where the law is being made. Congress passes relatively few statutes now, and the ones they pass, some of them are just ceremonial, like giving out a gold medal or something. So when you look at congress.gov and look at the public laws, you'll see they're averaging, like 180 laws, per year or something like that. Agencies are issuing over 3,000 rule regulations each year. And in terms of adjudications, federal agencies adjudicate far more cases than all of the federal judges put together. Why? Because life is complicated. Modern life is especially complicated, and Congress can't do what the agencies do. They don't have the expertise. They can't keep up with developments. They delegate the authority to agencies to figure out how to regulate things, how to regulate drones, how to regulate AI. Can Congress do that? No, we're going to have to delegate that to expert agencies. And similarly, with respect to adjudications, do we want the federal courts with all the Article 3 judges, lifetime tenure, to be the ones deciding 800,000 Social Security disputes every year? No, that wouldn't work. So Congress has found a way to delegate adjudicative authority to agencies. The Supreme Court's starting to cut back on that a little bit. But there is good reason for delegation. That's my main point. And secondly, the idea that, Supreme Court has been saying in many cases, Congress can fix this if there's a problem. Well, that's kind of true, but take the Voting Rights Act, where the Supreme Court has basically gutted the Voting Rights Act, and they've said, well, if we've done something wrong here, we've misinterpreted the act. If it's not necessary anymore, Congress can fix that. Oh, what's the likelihood that Congress is going to pass a new Voting Rights Act or an amendment to the Clean Air Act? That's why the agencies are operating under a lot of old statutes, because Congress has become so polarized that they can rarely pass new legislation. Occasionally they can, but very rarely. So this idea that, well, if we're wrong, Congress can fix it, unfortunately, to me, is sort of a non-starter and more of a rhetorical point than a real point.
Okay, thank you. Let's move to questions from the audience. And we have microphones that will come around. You can see this guy in the striped shirt over here. We'll take questions from students first. Go ahead.
So this is from Mr. White. You talked about how you thought that the Federal Reserve didn't come under some of these same that are federal agencies, because you saw them more as a monetary agency rather than a federal one. I would just ask you to elaborate on that, and are any other notable agencies this applies to?
So he asked, could everybody hear the question? He asked about the Federal Reserve. There might be other agencies that fit this category, but I'm not aware of them at this point. I mean, there are some agencies that are just clearly non-executive. The Civil Rights Commission, they do reports and studies.
They don't do any regulations, correct?
The Civil Rights Commission.
There's ANCUS, the Administrative Conference with
Professor Lubbers used to lead. There's a lot of agencies, but the Fed, the distinction I'm drawing here is the monetary policy.
beginning with the first Bank of the United States,
Which Congress created as a more or less private institution with a government-appointed board of directors. Beginning with that, the second Bank of the United States, and there's a long interregnum, and then you get the modern Federal Reserve System. Federal Reserve was in the beginning
a banking entity, collection of banking entities.
to carry out what we now think of as monetary policy.
Over time, it received some regulatory powers.
Especially in the Dodd-Frank Act of 2010. The Federal Reserve, I think, does have some things that we would call executive power, and I think that makes it a harder case than it otherwise would be. But even then, I think the Fed's center of gravity, in fact, its overwhelming importance and power, is on the monetary side and the supervision of the government chartered banks, the Federal Reserve banks. Its power to regulate purely private entities
Is a much smaller thing.
That's why the Fed is such an important issue.
I used to sue independent agencies.
Quite honestly, I used to be, my second law firm would challenge the constitutionality of the Consumer Financial Protection Bureau. And people would say in response, well, if you succeed in bringing down the CFPB, that's the end of the Fed. And I would look at them like they're crazy and say, what are you talking about? The Fed is so different. It's our monetary agency. Over and over again, people have tried to equate the Fed to these other much more regulatory agencies, and I think it really is a false equivalence. There's nothing like the Fed. The very reason why we're so alarmed that the Fed might be under direct presidential power is because its monetary power is so unlike anything else that the president or that other agencies have.
I guess I would just say there are other agencies I'd be alarmed about too. And what about the Federal Election Commission? And there are bank regulatory agencies and others where Congress had some good reason to try to make them independent.
And just to draw the distinction, I'd say I would be much more comfortable with
Even the FDIC or the comptroller of the currency, which regulate financial institutions, or the Securities Exchange Commission.
it's a constitutional matter. I would be much more comfortable
With even those agencies being under presidential control, that's how different I see the Fed.
Other question?
This question's also for Mr. White. You said that you like what the courts are doing right now when it comes to like making sure that we're not always delegating to the executive. And you said that that's the first step out of the cul-de-sac. What do you think is the next step?
The next step is
Congress learning to do its own job. Professor Lubbers, when he described it, is true. Congress is totally inert. Presidents love to say, if Congress won't act, I will. But I think actually the opposite is the more dynamic effect. Congress isn't acting because presidents will. We see over and over again, Congress waiting for presidents to take the lead on policy issues, do things unilaterally. Republicans in Congress did this on the border wall a few years ago. Democrats in Congress did this at the beginning of Obama's first term over climate policy. Over and over again, I think it's the president's capacity for action, which really makes Congress much more inert. All the political energy gets channeled in our system into the agencies. I think what Congress is, and I think that it drained a lot of the political hydraulic fluid out of the Congress. I'm hopeful the Supreme Court and other courts in squeezing the discretion that agencies have on policy will, in the long run, or maybe even the medium run, channel more political energy back to Congress.
where Congress has to learn to do its own job by taking power
Out of the leadership and bringing it back down to the committee level where they actually negotiate and discuss legislation, where they would if they were doing that kind of thing anymore.
That's the next step, I think.
Courtney?
I guess I would just add that doctrines like the major question doctrine that the Supreme Court has come up with that basically says that an agency can't take an action of vast economic or political significance unless Congress has provided a clear statement of the power to do so. And they've applied that in a number of cases recently. That's sort of telling the Congress, look, you got to provide a clear statement if you want the agency to do this sort of thing. But the problem with that is it's sort of a, and I don't know what the right phrase is, it's kind of a anti-regulatory ratchet in a way, because if Congress fails to do something, that means there's not going to be any regulation. And it's a lot easier to not do something than it is to do something.
Thank you. Okay, right there.
I have a question for Professor Lubbers. You've mentioned the major questions doctrine a couple of times. I just had a general question. Do you think that it's a pro or anti-democratic rule?
Well, pro-anti-democratic. I mean, I think the court would say it's pro-democratic because they're trying to get Congress, who represents the people, to make clear statements about what agencies can do. So in that sense, I suppose you could argue that it's pro-democratic. But why should there be a clearer statement for certain things than for other things? And if the courts are going to determine that, then it's going to be up to the courts. It's, in a way, it's a aggrandizement of the courts, and they're kind of taking power away from the other two branches because they're determining what a major question is. And the court is the least democratic.
I would just agree that
I think overall, I think it is pro-democratic, but the most anti-democratic danger in it
is that sort of standardless.
the court has created that judges will implement.
But I will say that it's taken some of the steam out of the non-delegation doctrine, because if a court holds that the Congress has failed to provide an intelligible principle for the agency to act under, and therefore it's a violation of the non-delegation doctrine, they have to hold the statute unconstitutional, the whole statute. If they declare that an action that the agency took is a major question, and therefore it's ultra virus, then it's only that action that's overturned, not the whole statute. So it's more of a a laser, pointed, weapon than this omnibus weapon of a non-delegation now.
Okay, thank you.
Thank you. I want to do a quick request of the crowd. Everyone who has TikTok installed on your phone, please raise your hand. Okay. Yeah, all of you have an app that under US law is currently banned in the US. See, and I hope you've been following this case. President Trump keeps signing extensions of the law banning TikTok when there was only supposed to be one eligible extension, and he just keeps continuing to refuse to enforce the law. This is a question to both of you. How do you think that Trump's refusal to enforce the TikTok ban and just taking it into his own executive authority affects the balance of power, and what do you see as the trend in executive authority that poses? Thank you.
First of all, I'll say that as a policy matter, I think this is one area that I support Trump. I mean, I don't think that TikTok should be banned. So on that score, I think I'm on his side. But, he is violating a clear law passed by Congress. The problem is, who has standing to challenge the violation? If none of the other tech companies are going to step up and try to challenge it, and if Congress isn't, hold hearings on it and complain about it, then he's able to do it.
So I actually agree.
This is funny. This is the one time when you're kind of to my right and not just sitting here. I am very, very anti-TikTok. Very anti-TikTok. Not very successfully. My spouse and my kids have all outvoted me in my house. Very TikTok-y house. I am sort of on one level. I think President Trump is just flagrantly violating the law and flagrantly violating his constitutional responsibilities on this one. I agree with Professor Lubbers. It's almost impossible to find a way to sue to overturn this. And believe me, I've talked with a lot of people trying to think it through. But maybe this is just to have some fun here with the debate. Can I ask you a question about this? How is, to the extent that it is a problem that President Trump is not enforcing the laws, how is this any different than President Obama saying he's not going to enforce the marijuana laws? Right? We've over and over again in recent years seen presidents or President Obama saying, I'm going to significantly ratchet back my enforcement of immigration laws, the original DACA policy and the DAPA policy. For years, conservative legal scholars squawked under President Obama that he was not faithfully administering the laws. It's a little quieter now on TikTok, I've noticed, under President Trump. I see it as all of a piece, and I feel very, very sort of vindicated that this is just what I was complaining about under President Obama. Am I being uncharitable?
No, I mean, I think it's just a good point that both sides can make, and I think it's a complicated area of administrative law in terms of what constitutes illegal non-enforcement of a statute. If an agency decides it has other priorities and wants to enforce something else, then they can probably do that. They can reduce the enforcement, and I think that Obama would argue that they still did deport some people, and so therefore it was reduced enforcement, not complete non-enforcement. I think the TikTok thing's a little more glaring. Yeah.
Okay, David Epstein.
We have two different founding principles, separation of powers and the unitary executive, both of which seem to be violated by independent regulatory agencies. But what I can't really understand is why, once you violated it by delegating power that is quasi-legislative, quasi-judicial, and quasi-executive, doesn't it make it worse to insist on a unitary executive controlling these things? I mean, why doesn't the fact that something is a regulatory agency mean that it is really legislative? I mean, the other things maybe shouldn't be there, but fundamentally it's making rules. So, thinking that the unitary executive ought to control that seems like it only aggravates the problem of delegation.
Oh, I was just going to say, don't forget the necessary and proper clause. I mean, that gives Congress a lot of authority to pass laws that they feel are necessary to carry out all the other functions. And, there are a couple of Supreme Court justices, I think it was Souter and Stevens, that said, why don't we just be real and admit that Congress can delegate legislative authority?
So I want to actually give another example that I think backs up your point. For 50, 60 years, maybe more, Congress would delegate enormous power to the agencies, but they would also put in a statute a legislative veto, right? The president, if he took action with that delegated power, Congress could veto it. The Supreme Court took away the legislative veto. They said that's unconstitutional. And it might have been Stevens. It was definitely Justice White. No relation, sadly. That guy was awesome. Justice White, the former football player, then Supreme Court justice, who said, this is a total bait and switch. Congress had both this delegation of power with these protections. Now the Supreme Court's taken away the protections and just left behind this enormous delegation of power. It's a totally fair point. The same thing here, that there's all these procedures and independence and so on that was meant to make these delegations safe for the rule of law. But these issues reach the courts one at a time. I think on the delegation side, it's become such an enormous constitutional problem that I am glad the court is pushing back against it. When it's an executive power case, does the president have the power to fire this member of the Federal Trade Commission? I think the constitutional question of executive power is pretty clear cut. It is going to leave, I don't want to sugarcoat it. I do think it leaves some real practical problems and some real possibilities of the abuse of delegated powers by the president overseeing that agency. But the only way I think we're going to back the truck out of this constitutional ditch and actually restore Congress's role in the policymaking power is by taking away some of these ad hoc precautions and saying to the courts and to Congress, we can either get back to the original system of Congress making laws and the president having much less discretion, or we're just going to continue to have these strange situations where nobody's totally accountable and nobody is totally in charge.
That's like saying, if we can make the situation bad enough, Congress will eventually step in and do something.
I'd say that's a fair point. It's almost like saying, maybe we take away football helmets, people won't play so hard anymore. We'll take away seatbelts and people won't drive so fast. I take the point. But I do think right now the task is showing the court, showing the lower court judges how actually dangerous the situation is. And these other little precautions, like the rulemaking process, like the adjudication process, like some measure of agency independence, I don't think they protect us nearly as much as they do. And I think they scatter the accountability for actual decisions in government much more than they were supposed to under the original Constitution.
We have a queue of questions.
Oh, sorry.
For Michael Cochin of Tel Aviv University and Catholic University, then we'll go on Zoom, and I've got a few student questions.
It's the camera. I've been like wondering where people are watching us. Oh, it's back there.
For Mr. White, perhaps one should temper the defense of the independence of the Federal Reserve with the general consensus the economics profession. Federal Reserve hasn't done a very good job. And the way from the Great Depression, even with Great Recession, it's unclear that this agency has performed very well. And if you want good administration, maybe you think about the connection between a setup and
Can you speak up to the microphone?
we need to think with defending the independence of the Federal Reserve, we should think about how well it's performed, and the general consensus of the economics profession is that it hasn't performed very well. With regard to immigration, which Professor Lubbers brought up, so we had kind of a great degree of non-enforcement by Mr. Obama, and a truly stupendous degree of non-enforcement by Mr. Biden. This creates the situation that Mr. Trump has to deal with. Okay, and if you add to that an absolute defense of birthright citizenship, right, it looks like that this is not only a difficult problem to fund it, you have to fix it very fast, or you wind up with a tremendous legitimation crisis. So within your profession of administrative law, what do you think are the steps that need to be taken to actually enforce the immigration laws passed by Congress and get an immigration policy that is useful?
Can I go first? You want to know about the Fed?
So the point is well taken. He said, why should we worry so much about the Fed's independence? Or maybe let's not worry too much about the Fed's independence when the main thing we should worry about the Fed is that it performs poorly. It's always behind the curve. I could add to that. The Fed, I think, has gone way overboard on its mandate. It's pulled way too many things nominally into its framework of risk, including climate risk and other things that I think go way beyond what the Fed was actually supposed to think about. I think the the members of the board of governors and the presidents of the bank spend way too much time on TV pontificating on a variety of issues when I wish I actually didn't know their names and that they were basically anonymous and worrying about monetary policy. I think Kevin Warsh, a former Hoover Institution colleague of mine, has been an excellent critic of the Fed, and he would be a great chairman. Even all that said, I wish the Fed, even while shrinking its mandate a little bit and being better at its job, still had that space to operate our monetary policy, which I don't see as quintessentially executive.
On the Fed, I just think that I don't know that much about it other than to say that the Fed's done a pretty good job in the last few years, giving us sort of a soft landing from the pandemic and the infusion of money afterwards. In terms of immigration, again, it's a very tough issue. I think I was speaking more about the dreamers and so forth, and which I supported letting them stay in the country. But under enforcement at the border, that's maybe the Biden administration deserves some criticism for that. But don't forget President Reagan granted an amnesty to the people who are here illegally. And, the theory was we were supposed to have half the citizenship and greater enforcement. And the Senate almost passed, or Senate did pass the bill, I guess. That's the only answer that I think should be that. But it's like calling for a two-state solution. It's hard to bring it home.
Next question from online.
Okay, so this is a question from David Fott. Members of Congress will not reassert the authority of Congress without an incentive to do so. What would that incentive be, and how would it be instilled in them?
Maybe that's for me first. It's a good point. I think, first of all, my first point, as I said earlier, is I like when the court is doing things that channel political energy back to Congress. Actually saying, you don't like climate policy? Go to Congress and actually debate this for a while, members of Congress. Don't just stand up and say, here's what the EPA should do. So that's the first thing. Second, I do think there needs to be filibuster reform so that Congress can actually bring things to a head and legislate. I wouldn't want it totally done away with, but I think the filibuster and other procedural checks in Congress are mostly now just tools of obstruction, almost akin in the way they operate to the old gag rules of the 19th century in Congress. Obviously, the gag rules were about the worst issue of all, which was slavery. But I'm saying today the filibuster is mostly just a gag rule. And third, I think that anything we can do to bring power out of the leadership down to the committee level is a good thing, where members of Congress actually work together. I know this sounds hopeless, by the way, but I'll tell you, my job at AEI, I talk a lot with members of Congress, frankly, mostly Republican, but not just Republican. A lot of younger members of Congress who are new and still making up their minds on policy. I find it really refreshing that there are young members of Congress who, even when they agree with President Trump on policies, they'll say privately that, my job ought to be to actually legislate on these things and not just sort of celebrate whatever the president does. There is some of that there. And the goal is to really instill that and reinforce that with them before they leave. My favorite congressman from one of my favorite states, Wisconsin, Mike Gallagher, retired to go to Palantir. And I wish he was still in Congress. Maybe there's one small change that I would make. I wish Congress would prohibit naming laws after acronyms. I don't know if it started with the Patriot Act or what. Laws used to be named after random members of Congress who we've long forgotten. Maybe it'd be a good thing if the legislation was named after members of Congress again, to actually make them ambitious to want their names in the lights again. I didn't like that one as much.
I guess I would just say if we could make the districts more competitive, it's really unfortunate the Supreme Court has bowed out of reviewing gerrymandering for the most part. So if members of Congress are more worried about being primary than the general election, that creates lack of incentive to legislate.
Okay, we have 5 minutes left. I see several student hands. So let's just have you ask your questions and then you'll field
We'll do our
all of them, yeah, as you can. So first, the gray shirt here, yeah.
Hi, thank you for your time and your opinion. I speak for myself when I say that I think in this day and age, it's very prevalent to have you here. And I'm sure many other people in this room agree. My question is to either of you, but specifically regarding something Mr. White said. You mentioned how many agencies will be affected possibly in a detrimental way due to Trump's actions. You referenced specifically NPR and PBS, and I'm wondering what either of you think the future for these two industries and other agencies that have been cut in detrimental ways, what that might be.
Thank you. Right behind you.
My question just has to refer to what Professor Lubber was saying about legality versus a violation of norms. So I have my own opinion, but I was just wondering, like which one you think is more devastating or dangerous, especially in this precedented time, a violation of legality or a violation of democratic norms.
Thank you. Over here. Yeah.
My question is more for Mr. White, based on something Professor Lubber was saying. If your claim that if things get bad enough, Congress will act holds true, how many more sirens have to blare before Congress takes action? We've already seen the occupation of cities, the censorship of media, and more with little to no response. What else will it take, and how should citizens respond to the idleness of Congress?
Okay, and then one last one right here.
My question also goes off of earlier, a lot of the discussion about how to get Congress to act. So you talked a little bit about the primaries, but I also know there's a big fear among Republicans of going against Trump, especially if we think back as far as like the Kavanaugh confirmation, when he was telling people like, if you don't support Kavanaugh, you're going to get primaried by me. I won't put my support behind you. How do you think, is there any way like Republicans can overcome that if they have disagreements with Trump? Or do you just think at this day and age, that's not something that can happen right now?
Hey, you've got your hands full. Take them as you wish.
Why don't we,
I'll answer one and then you answer one and we'll run out.
I
I want to start with the question, how bad does it have to get? Because I grant the premise, it's horrific. It's absolutely horrific to see what's happening in the cities with this new style of law enforcement, especially with ICE. And I want to be really clear here. To the extent I said earlier, I didn't mean it this way. I didn't mean maybe if things get bad enough, things will get better. I've started learning about this thing, accelerationists or whatever, who say this should just stop. That's not what I'm saying.
I don't mean that.
What I mean is, I want Congress to see, I want them to relearn that it's their job to take responsibility for these issues again. And if they don't think that the agencies are just the escape hatch for congressional responsibility, that I think would be a good thing. But I was not endorsing what's happening today, which I find horrific on so many levels. I don't have one more, but why don't you go?
Okay, well, just on that point, I mean, I think, what can you do? I think when I was your age, you know, we were demonstrating against the Vietnam War, and it sort of worked, you know. I think people have to, you know, do everything they can to show their displeasure with what's going on, including going out on the street. Secondly, I guess with respect to what agencies besides NPR and PBS are going to be hurt, I mean, first of all, everybody should contribute to WAMU, and I do.
Me too.
But so I think there are other agents, you know, foreign affairs agencies have been hurt a lot. Agencies dealing with the arts, museums, you know, so many. Department of Education has been pretty much sidelined. If you look at where the staff cuts have been and the budget cuts have been, you'll see which agencies have been really hurt. With respect to norms versus legal questions, yeah, norms can become legal questions if they get legislated into law. And I think sometimes when Congress has provided the president with emergency power and it hasn't put any restraints in that delegation, they should rethink that and put some restraints in it.
Norms, just really briefly on norms.
I mean, breaking norms versus breaking laws, I mean, they're both bad, right? And laws are bad, breaking laws are bad in such a concrete way. When you read George Washington's first inaugural address, the first 8, 9 inaugural addresses. They're all about duty, both the way they said I'm bound, both the words they said and the way they described what they were doing. It was all about being bound. And so violating norms, I think, is fuzzier, but I think it shows just a sheer lack of restraint by presidents. I worry about it a lot. But I'll just end by agreeing with Professor Lubbers on agencies. Like I said, I love PBS. I think it's been great. Its programming for local communities is very important, especially on things like local news and nature and science. I see them like modern museums and an adjunct public schooling. I'm a huge fan. I've got to admit, as a political conservative, I'm not as much a fan of NPR. I do love the classical music. I like some of the shows. When I was talking to senators and their staff about being on the board, they'd often say, "You keep saying how much you love PBS, but you don't talk about NPR that much." And I'd say, "Well, maybe we shouldn't get into that." I do wonder about the role of public supported talk radio in the podcasting era. And so I'm less worried about that. But I do think in terms of arts and education, it's incredibly important. And to, talk about one of my favorite American University alumni, Jamie Fly. He was recently the head of Radio Free Europe, Radio Liberty. Twice. He was there, Trump fired him, he came back under Biden. I think that America's radio stations and messaging abroad, Voice of America, Radio Free Europe, Radio Liberty, and all the others that came out of the Cold War, was some of the most important and best things that we did after the Cold War. Soft power, and making the case for freedom and liberty abroad. And so I really am sad to see that go. I think so much of what we're seeing right now shows just a lack of confidence in America's own ideals. I think our opposition to immigration shows a lack of confidence that America can make Americans anymore. And I see the same thing with the collapse of Radio Free Europe, Radio Liberty. And I think it's such a small thing policy-wise, but I think it's one of the saddest signs of the time.
Just say two more things. We're all immigrants, right? If you look back in our history, unless you came over on the Mayflower. And secondly, if I was as young as most of you, I'd be so upset about what's going on with reduction in funds for preventing global warming, because it's here. I mean, it's happening every year, it gets hotter and hotter. And you've got, 60 years ahead of you of super hot weather. I'd be really upset about some of the policies that are being done now to, end, all the alternative energy sources that we've been trying to subsidize. So that's what I'll sell.
Well, I think you both executed your responsibilities faithfully and so please, join me.